can be called to account.
Thank you very much. That's excellent. Now, Deputy McClellan, I think you might have one or two questions, have you? And we have others as well who have indicated.
Okay. Firstly, I'd like to take this opportunity to welcome you here and thank you very much for your presentation. The role of personal insolvency trustees is crucial to this legislation. As the body who deals with much of this area, what specific recommendations do you wish to make to ensure that we don't have a situation where, say, cowboy or unqualified people enter this field? And I've second.
Take that first,
okay.
So maybe for Hughes, perhaps.
We're not the body that deals with this. In fact, we're a society that was set up at our own behest in the context of endeavouring to ensure that there's an ongoing education and review of the procedures and policies. So we'd like to think we're the body, but we're not. Just in terms of the regulation, from a corporate side, we've been advocating regulation for a number of years now, because we would be concerned, in terms of corporate insolvency, we'd be concerned that it is an open field in the context of the manner in which people can operate. And I think when you bring that to a personal level, I think it's all the more reason why it needs to be regulated, because dealing with corporates is somewhat removed. Dealing with personal, it is by its nature very personal, and I think if nothing else, what we would be advocating that in terms of the mistakes that have been made on the corporate side in terms of legislation and regulation, if you could learn from that and enhance this legislation to ensure that those mistakes are not made on a personal level. So we would be very strong in that area.
Mr. Holohan.
Essentially, at the moment, in terms of corporate, for example, the two criteria are that you have a heartbeat and you not be connected to the company. In terms of the personal side, we've seen the central bank having to intervene in certain cases with money managers. Now, you use the expression cowboys, but we are entering a Wild West territory, and we are going to get the cowboys coming in. The members of ISIP are drawn from the ranks of the legal profession and the accountancy profession. And in the legal, it's primarily solicitors. We have one barrister member at the moment. Ross hasn't applied yet for membership. But the lawyers and the accountants are already regulated, bonded, licensed, supervised, and that is the system you will need. Now, whether you decide that you can find it there to the start and look at others in some other form of regulation where it doesn't exist at the moment, it's a no-brainer from my personal point of view that you have a core of people. I've described it internally as that if you take the army analogy, the solicitors and accountants are the army, the ISIP are the Army Rangers, and at the moment you need the Army Rangers for the problem.
Yes, Mr. Hall.
One of the sections that refers to the insolvency trustee does, say New Beginning, MABs, or anybody else has insolvency trustees, it does require the insolvency trustee to be impartial. And that proves a great difficulty under the current phraseology. Therefore, if MABs ourselves or anybody else had insolvency trustees, FLAC, anybody has insolvency trustees, there's a question mark in relation to how a lending institution might deal with that, and legitimately so, that if somebody is seen to be more on behalf of the borrower, they're supposed to remove themselves from that and be independent. And as Bill and others have said, it's absolutely imperative that a Wild West situation is prevented at all costs, and the most stringent regulation is introduced.
Just a second question
of course,
there. You are proposing changes to the debt relief certificate. Can you outline what arrangements are in place in other countries for smaller debts, and what threshold would you have in mind?
I'm going to pass that parcel again. At the moment it is €20,000 or less, but you can run that up very quickly for somebody with a credit card bill. And in the days when you had people who had more money available to them than sense available to them, you have people who have no income, no assets and liabilities which exceed that figure. In terms of practice, you could do a straw poll, but I certainly know of, from my personal experience, of over 10 cases I could name by name where the debts on consumer spending, if you like, are over 50,000. Now, again, it's a political judgment as to where the line will be drawn. But that's some of the reality that is out there. Also, you have a situation where there's a perception in certain quarters that this legislation is to deal with the professionals, with the developers. It's not. And I'll give you a simple example. Yesterday afternoon, I had a couple, and I got their permission to outline their circumstances, but not name them or identify them. He was working in SR Technics, an aircraft engineer, specialist qualification. She was a beautician working in a beauty parlour. He was made redundant along with 1,300 others. She was let go because people aren't spending money on beauty products. They had bought in 2005-2006 a small 2-up, 2-down terraced house in a new development. No income for a number of years. They sold the property. They lost money. They sold the car. They sold everything. They are now on social welfare. He, with his technical qualifications, is being offered work at €10 an hour, but he will lose all the additional benefits, rent allowance, etc., and it does not make economic sense for him to do it. They are being hounded, and is the only way to describe it, because I saw the correspondence from the financial lending institution involved, who are left holding the undischarged balance of the debt. A number of times a week they're receiving calls. She is pregnant with a second child, and I've seen the medical evidence where she is stressed, suffering from irritable bowel syndrome, from blood pressure, a host of other medical conditions brought on by stress of dealing with this. And notwithstanding having outlined all the options open to them, they are seriously thinking, notwithstanding the prospect by summertime or autumn of a 3-year bankruptcy system in Ireland, they're seriously thinking about going to England, leaving behind their family support structure here and throwing themselves in the social welfare system in the UK because of a prospect of hope. And that's a small example in the debt relief certificate area, so to speak. But their particular debt, the residual debt, having sold everything, including the property which took a dive in value, is over 100,000.
Again, you remind us of the real human pressure that's out there. And I think we must never lose sight of that. It's very, very important. Thank you for that.